Cybersecurity Center of Excellence, Data Security Council of India, Ms. Mishi Chaudhary, founder, SFLC.in, and Mr. Nakul Batra, associate partner at DSK Legal. A very warm welcome to you all. Over to you, Mr. Upadhyay.
Thank you so much. Good evening, everyone. As the subject mentioned, I'm talking about an interesting aspect which talks about financial crime and privacy. Both are starkly opposite subject, but of late we have seen, due to the complications of financial crime, the privacy angle getting into the situation. Of late, if you look at what has happened with us in the last 10 years, the kind of financial crimes, the nature of financial crimes have evolved a lot. Traditionally, people used to steal and do some kind of basic mischief and pay out money, but now we see more and more use of technology to steal money, to siphon funds, to do financial crimes, and various elements to deceive the individuals, which has led to significant use of technology. And as we talk about the other element which connects is about the privacy. On one hand, we as users of technology have mammoth amount of personal data and sensitive data stored across various platforms, across various geographies, across various operators who handle our data. So now what happens where there is a financial crime, and on the other hand, the data which is connected to the financial crime is also the personal data of various individuals, including that of the suspects who are accused of crimes. How do we balance it to ensure that the privacy is not violated, the individual's confidentiality of important and sensitive data is protected, and at the same time, how do we ensure that justice is delivered to ensure we minimize and prosecute the financial crime on a very real-time basis? So that's the challenge we are facing, and that's the point of discussion we are going to do today. How do we balance financial crime vis-a-vis privacy? So as you know that we have esteemed panel from various areas of expertise. Let me start with Asim. Asim has been lawyer and has been involved in several cases of matters related to technology. Asim, what do you see the linkage between financial crime and privacy? How do we handle that as a challenge? How do we protect the privacy of the individual? And at the same time, how do we balance the concept of justice towards the financial crime? Over to you, Asim.
Thanks a lot. Thank you very much, Ajay. So the topic is striking a balance between financial crime, privacy and financial crime. Now, the financial crime is not a defined term. It could include corporate fraud, bribery, corruption, inside dealing, money laundering, and terrorist financing. And there are a whole gamut of laws which deal with financial crime. So coming to privacy, we all know after the Supreme Court decision, privacy is our fundamental right. And the current data protection regime, we also know, is inadequate. It's not a very robust data protection regime, but the proposed one under Personal Data Protection Bill 2021, which is pending before Parliament, is a very robust one. The transaction today have become very complex due to the involvement of multiple entities, technology platforms, volume of personal and non-personal data the transaction requires, and cross-border flow of information. Now, all this poses a challenge to enforcement agency in case an inquiry or investigation of financial crime. Now, in a normal situation, the law mandates that the consent of data principle in case of personal data is disclosed or transferred to a third party. However, in certain situations, like inquiry or investigation of financial crime, the sharing of personal data is not subject to the consent of data principle. While it will be difficult to specify what kind of personal data should be shared with the enforcement agency, as it is their discretion and they are the best judge depending upon the facts of the case. However, the law can specify procedural safeguards for obtaining such information or specify obligations on enforcement agency as to how to handle such data so as to strike a balance between privacy and investigation of financial crime. Now, if you see the current law, for instance, under sensitive personal data or information rules which were issued pursuant to IT Act, the rule states that sensitive personal data, which essentially are, the data relating to your bank accounts, financial data, health data, they can be shared with the government agencies subject to the following safeguards. Number one, it should be mandated by law. So it has to be mandated by law. It is not at the discretion of a enforcement agency. Second, request should be in writing. It should have a specified purpose, and such information should not be published or shared with any other person unless mandated by law. So this is a procedural safeguards and other safeguards which this rule mandate with respect to personal data. That's the current law. Now, in the proposed Personal Data Protection Bill, there are different categories where data can be processed without consent of data principal. And one such exemption is in section 36. And what this exemption essentially says that in case of processing of personal data relating to prevention, detention, or investigation of any offense, in such a situation, most of the provision of PDP bill relating to the rights of data principal are not applicable. However, certain safeguards are provided. And these safeguards essentially accord a protection to that personal data which is shared with the investigating agency. Now, what are these safeguards? These safeguards are no personal data shall be processed by any person except for any specific, clear, and lawful purpose. Now, the security agencies have to implement necessary security safeguards, including use of methods such as de-identification and encryption, all steps necessary to protect the integrity of personal data, and steps necessary to prevent misuse, unauthorized use, modification, disclosure, or destruction of these data. So these are the safeguards which are in the proposed bill. Now, it is important to note that the exemption from consent of data principle as per the Supreme Court judgment of Pithuswamy should satisfy 4 steps. And these steps are that it should be backed by law, it should serve a legitimate aim, it should be proportionate to the objective of law, and it should have a procedural safeguards. So these are some of the safeguards which are specified there. So while it is important that investigative agencies should get data, personal data, whatever it wants with respect to financial crime, at the same time, it is also imperative that such personal data should be given some safeguard. So that essentially is striking the balance between privacy and financial crime. I think I'll stop here for the time being.
Thank you, Asim. I think that's really helpful. In fact, these safeguards, you're absolutely right, because the way we look at what is happening on some cases when they blow out in media, we see that certain amount of personal information is thrown all over media and people kind of gossip and pass judgment. So I think you rightly said if the proposed law gets implemented and the safeguards get implemented, I think we'll have some bit more of confidence on how the privacy is handled vis-a-vis financial crime. Thank you for that. Nakul, you have been dealing with such situations in your experience, and we have also seen a lot of evolution in our technology and vis-a-vis, evolution of how the privacy is controlled. How do we see and how do we protect the privacy and see it from the light of innovation and technology and ensure that, the privacy is protected? What's your view on that?
Thanks, Ajay. So, coming from a technology background and being a lawyer, it has always been a problem that technology is always 2 steps ahead of the law. Whatever law we create, there are always people who are ahead, find ways to circumvent the law and commit certain kinds of crimes which the law even does not contemplate and it can't address it. Most financial crimes in the today's world based on money laundering or fraud are conducted by organized criminal groups who leverage on the new age internet we have, you know, the new transfer, the money transfer mechanisms which we have, payment wallets and everything. So what we have seen in these times is that there are new and new ways coming up in which law has to deal with. While Mr. Abbas was, you know, very rightly identified and elucidated the safeguards under the law which we have to prevent unnecessary disclosure, uh, and so yeah, before I go to that, there has always been, you know, a disproportionate balance between what to disclose, how to disclose, and when to disclose when it comes to financial crimes. Whenever there is a financial crime, to investigate a financial crime, you need disclosures of certain extent. And when I talk about disclosures and protective regime, you need to share information across all platforms in the financial institutions which are dealing with such criminal activities. Now, whenever you talk about the sharing of information between these financial institutions, privacy law comes into picture. You know, it's an inversely proportion between privacy and the disclosures requirements by the financial institutions. Now, when I talk about the compliance cost which these financial institutions are incurring, it is all because of the new privacy laws which they are subjected to. Okay. Now, there are ways and means by way of which you can have some sort of an arrangement where information is disclosed, distributed, and basis that financial crimes can be prevented. Since this is a new age of technology basis which crimes are happening, this has to be circumvented by technology itself. And while the law puts some baseline conditions and criterias, uh, which we are going to see very soon in the form of Personal Data Protection Act in India upcoming. GDPR has it. California Consumer Privacy Act is their well evolved law which highlights all of these instances. We are in which financial institutions can share across and prevent crimes. I believe many industry leaders like TCS, IBM, you know, they're all coming up with white papers to say how can technology help and technology help curb financial crimes uh, without uh, without targeting privacy, and you know, exceptions to privacy are not defined. So that's my two bits on that. uh, One more item which I need to share is that, you know, there are law enforcement agencies which have been given the power to ask and seek disclosures from individuals about individuals data. While the law is yet to come, we have certain baseline conditions, but we see that the law has been evolving over a time, and there are still certain laws which provide the disclosures of such nature under, you know, there is the Code of Civil Procedure Code is there, which requires disclosures of information, and there are approximately more than 10 kind of Indian authorities which can seek disclosures from various industry participants. Now, this law is well awaited, which can address issues on, you know, the bombardment of such requests from law enforcement agency. As of now, we just have a few laws, but the data protection bill, when it comes into picture, would really help in curbing those requests from law enforcement agencies.
Thank you, Nakul. I think you also believe that, you know, the data protection bill might help us in improving the overall privacy angle. I think all of you would agree on that. Uh, Moving ahead, so Dr. Sriram, you have been veteran in this field. You have seen the world evolve, specifically India evolved from a technology perspective, from how we see data, how we see information, how we see privacy evolved over last 15, 20, 30 years. According, you know, how important are concepts like public-private partnerships, and what are the technological challenges we see on the concept of, you know, privacy And what are the benefits and risks of too much privacy and too much investigation? What's your view on the concept?
Thank you, Ajay. A very interesting topic and a very knowledgeable panel indeed. So it's a privilege to meet all of you here and address this gathering. So the first thing is that law enforcement, we have to see the extent to which this is happening. So that's the first, to get a assessment of the size of the problem. The regulators and LEAs, law enforcement agencies, have been working within their jurisdictional boundaries traditionally, and they do not have too much access to some information or criminal activities which are happening outside their jurisdictions. So this loophole is being exploited, and there are criminals who are laundering money of about at least estimated to be 2 trillion US dollars or so globally every year. So there is a strong need for a joint concerted action, a public-private partnership model, which even FATF, Financial Action Task Force, the global body, has acknowledged. And that is the reason, one of the things that has to be accounted for when you are evolving. So many privacy laws are evolving all around the world, and very often these money laundering fraud are often conducted by very organized groups, and who leverage all these transnational, international networks, multiple financial institutions, fund transfer modes, channels, and everything. So here also, in order to fight this, also you need to have that kind of collaboration and cooperation. So there are very many bodies that are evolving now. For example, UK's JMLIT, Joint Money Laundering Intelligence Task Force, or Netherlands Transaction Monitoring Netherlands, and so on. Estonia's AML Bridge, and many are there. So while all these laws are, others have commented on this, so I will not comment on this. There are, first thing is PETs, which is privacy enhancing technologies. That those are become very important now, so that there will be inbuilt privacy when you are sharing information. Some of the examples of PETs are homomorphic encryption, zero knowledge protocols, ZKP as it's called, trusted execution environment, secure multi-party computing, and so on. So what is really some of the challenges, and for which these need to be modeled properly? Data interoperability, and of course separating the KYC AML systems, and also data quality also, and encryption. So these have become extremely important. So what we are finally looking at is, powered by these PETs, that is privacy enhancing technologies, what we need is shared intelligence and industry benchmark risk and detection models, and regulatory feedback, collaborative investigation, and joint SAR filing, which is suspicious activity reports filing, and all of these are required. So how do we do this? There need to be a lot of synergies around. Basically, the core is the transaction behavior of different customer segments, and synergies of data and analytics surrounding all of these risk models and scenarios, and performances of different scenarios. And of course, we need loads of training data sets for AI and ML algorithms, so that these are automated. One cannot do this manually because there are millions of transactions happening around the clock. So this is my take on the thing. So these are the disruptions that we can expect to see in the coming years. Thank you.
Thank you, sir. I think these are insightful, and disruptions is what we are always conscious about, and how they create more and more challenges for us. Thanks for the insight. Moving towards the other topic. So Mishi, you have been forefront of a lot of studies, and you have seen the world both within India and outside globally. You have seen different perspectives around how privacy is treated. What's your view? What's your experience in India, and what's your experience outside jurisdiction? How it is handled? If you can throw us some light, please.
Sure. Thanks, Ajay. And thanks, everybody. I think the advantage of going last is everybody has spoken about most of the important themes here. So my law practice is based in New York, and of course, the work is also India-based. Overall, my perspective has been that, of course, we've seen that financial crimes have been on the rise. Another very important aspect is the rise of cryptocurrencies in contrast to fiat currencies and the transactions moving in that world. Now, many of these currencies would allow users to conduct transactions with much greater privacy, but that doesn't mean they provide total anonymity. So we've also seen a lot of blockchain analysis organizations and firms which are offering that as a common service. The third thing, which all of us have already touched upon, is the increased understanding that the world we live in means that there is going to be more understanding of data protection as well as privacy rights around the world. It starts with obviously the gold standard of GDPR in 2018. We've seen CCPA. I'm in the US. Every other day, there is every state which is coming up with their own set of protections, because US does work only with sectoral protection so far. However, the importance of all of this in geopolitics is now underscored. I'm sure everybody saw the Biden administration telling the Russians about how the ransomware will be dealt with. Again, when we talk about financial crimes, I am going by FinCEN, which is the US agency under Treasury Department, which deals with financial crimes definition, which is to say, follow the money. Wherever the money is, that's where the issues are. So I would say that from fraud to electronic crime, from money laundering to bribery and corruption, and from market abuse and insider dealing to sanctions, all are considered some form of financial crime. Some of it does form the front page news and some of it does not. In India, of course, now, in the last year itself, we've seen enough of the data breaches to a regular customer that is also a major issue, not seen the same way, perhaps by a different side of a financial institution. Now, so all of these are on the rise. We are seeing CCPA, we're seeing UK, other stuff which is coming up. But what I'll say is that financial institutions have been trying to do a lot of it on their own as well, along with collaborating across with each other. And they are a little better advanced in data sharing. And that's why when Dr. Sriram already talked about the privacy enhancing technologies, they are already thinking about the fact that there is going to be privacy by design built into a lot of the work which is going to come in future. So whether it is the homomorphic encryption or the zero knowledge proof, the tech is still using what might work in terms of what the obligations of these institutions already are. But even the Financial Action Task Force president recognizes that the new anti-money laundering frameworks or any advancement in the area must preserve the right to privacy and data protection. So that brings me to the last thing to say is that regulation, whether it is the Indian regulation or some of it, has not been able to encompass all of this. We are right now seeing that because a lot of this overlaps with platforms and different platforms getting into different kind of businesses, super applications coming, Facebook getting into virtual currencies, there are a lot of these strains of regulation which we would require. So to think about one siloed regulation is going to cover all of that is not going to give us the right answer. And considering I have represented a lot of open source based cryptographers as well as cryptocurrencies, I will say an ideal world solution, which is going to limit a backdoor entry into privacy protocols for regulators and law enforcement, is out of reach. That kind of a system of controlled access, it would be fantastic if math worked differently for good guys and bad guys. But that thinking is just flawed. It's not bad thinking. It's nice to think about it, but even well-meaning people as well as the hackers are going to definitely abuse that system. So to come to think of it, I have a golden answer of coming up and striking that perfect golden mean balance is just going to be a pipe dream from that perspective. And the other thing which I'm going to say is that although in India, the data protection bill has been pending for a very long time, there are two major issues. Even Justice Sai Krishna, who's been responsible for it, who's pointed it out, is about the introduction of the non-personal data framework, which was jammed into this bill, and also the way social media intermediaries are being handled. We watched the new IT rules and the traceability provisions. And if people are going to do financial transactions from messaging encrypted chat services, it means a very different kind of framework. And this bill, which all of us have been waiting forever, and every time runs into one issue or the other, is only the beginning of something which will lead to a privacy framework. We need a much more exhaustive framework to handle data protection as well as the right to privacy. To think this is going to be a panacea, it's not, no law is, and at least not one single legislation can ever do that job. And this is a much more rapidly evolving area in which we will have to do a framework in which guidance is provided to businesses, to financial institutions, and also simplicity and clarity to the users who are looking for simple ways to protect their data.
Thank you, Mishi. I think it's very interesting to know. I mean, specifically, we in India are still struggling and playing with the concept of blockchains and cryptocurrency, where we still don't have clarity on the regulatory side that will it be allowed, will it not be allowed, how do we kind of handle it? And of late, we have seen several cases in India which are primarily ransomware attacks, where the extortion is always asked in form of a cryptocurrency, and how do corporates are forced to kind of get out of Indian system, buy cryptocurrency, pay to the attackers, and get their data unencrypted. So I think you're absolutely right. I think that's an important element. We should think about it. In fact, Asim, I don't know if in your views, do you believe we are, I mean, when it comes to cryptocurrency and blockchain, do you believe that is an element where we have started to think it from a privacy angle? What's your view on that?
So blockchain is a technology, right? And I think there is some discussion which Niti Aayog has started on a blockchain. And if I recollect, the TRAI in its unsolicited commercial communication regulation mandates the use of blockchain in case of unsolicited calls. So we have sort of a one regulator who has mandated that a blockchain should be used with respect to unsolicited commercial communication. But as a technology, it will evolve. It has its own merits and demerits. Some people have raised concern with respect to privacy when it comes to blockchain, because there are certain rights which the data principle cannot exercise in the case of a blockchain. For instance, if it wants its personal data to be removed, it probably won't be possible. With respect to cryptocurrency, so there is a decision of a Supreme Court which is there vis-a-vis RBI circular. And I think last year, there was some discussion about digital currency, where the government wanted to introduce a bill essentially to handle a sort of a cryptocurrency situation. But these are very new and evolving area. Much needs to be seen how the sectors are developing. And more than that, I think the important thing would be how the government respond to it, to ensure that whatever the framework, regulatory framework we have, it should essentially facilitate technology and a new service to grow, rather than act as stifling emergence of a new area or technology.
Great. I think that's absolutely right. Nakul, everyone spoke about we having this personal data protection bill, which would be similar to something like a GDPR. And what we have seen, GDPR is very stringent in terms of how the data has to be processed, handled, transferred. All those things are quite stringent, and it's really intense how it is handled in European region. In your experience or interaction with various your clients, do you believe our corporates are ready to handle the law and protect privacy, and that same way be compliant to the law? What's your view on that?
So while we have read the personal data protection bill, and we are still advising on, the SPGI rules of 2011 and the IT Act of 2000 and, amended in 2008 and 12. We are still continuing to advise on the current regulatory and legal regime. We often advise on the upcoming laws and the consequences which they may have to face, and the change which they may have to bring in about, the storage, the collection, and then dissemination of data which they do. Uh, but since the law has not seen the light of the day, and we don't know when actually, uh, it has all been pending for the last 2 years, and as Mishi rightly pointed out, that this is just the beginning of one big piece of the legislation to come into picture. There'll be a data protection authority which will eventually be established. There'll be a lots of rules and regulations by the government which will come up in the future course of discussions. So for to answer your question, we do advise and tell our clients that this is what is going to happen, but it is always, with the condition that we are not sure. It is yet to come into our faces. And just to add on what Mr. Abbas said about the cryptocurrencies aspect is, so we have seen that lots of market participants have submitted their recommendations to government in order to have a legal framework around cryptocurrencies, and one of the items is that most cryptocurrencies don't have an audit trail. Most transactions on cryptocurrencies are anonymized. You can't trace from where it has come and to where it has gone. If you are able to answer and find a way to have an audit trail to check where it has gone, where it has come from, I believe the privacy aspect and the anti-money laundering provisions and aspects regarding cryptocurrencies can be solved to a certain extent if you do smart contracting in a way where you can find an audit trail. So that has been one of the recommendations out of many others to the government while we are contemplating a legal framework on this aspect.
Thanks. I think that's really important. In fact, Mishi mentioned that it's always important to follow the money, and till the time there is a trail, you can always investigate a financial crime, and also follow the money so as to ensure where it leads. Obviously, the risks of uh, privacy is always. Thanks, Dr. Sriram. You have dealt with several corporates, and what do you believe? What is your experience when interacting with these large industries, specifically when it comes to their preparedness of handling employees' personal data, protecting personal data? Do you believe that our corporates, specifically, you've seen IT sector, are they ready? Are they prepared to handle this situation?
So Ajay, the answer is going to be a mixed bag, because essentially it spans the spectrum. There are ones at the high end which are fairly well prepared, and they're aware, they're putting in the resources there to handle these. But at the low end also, there are the rural cooperative banks and such. See, in India, there's a vast spectrum. So you may think that tier one cities and all those where people are booking Uber cabs, watching Coursera and watching Netflix, and booking Swiggies and all these kinds of things, food and all these are there. But then there is across the digital divide, there is the rural India, wherein there also people are using definitely Jan Dhan, Aadhaar, E-Seva, booking tickets, doing all of these things, and more startups are targeting this population, bottom of the pyramid, also for healthcare apps, to various other agricultural apps and so on. So what would happen is they're a susceptible lot because the awareness is low. You heard of a lot of Jamtaras and all of these. And of course, they have not put strong regulations, I mean, frameworks in place as yet. Okay, we need to cater to those people as well. So there's a great deal of there's a need for awareness, and we are doing our bit. I mean, in NASSCOM, DSCI, and the Cybersecurity Center of Excellence, we are doing our bit in bridging this part, and everyone should. So once these regulations comes, we don't want organizations and people to be caught on the wrong side. So that's why at least basic things to be there. It's not that all the technologies need to be extremely expensive or the processes need to be expensive. It's part of doing the business. It's cost of doing the business, right? That needs to really sink in. And having said that, organizations are becoming increasingly aware. And then we've had cases where some organizations are astonishingly what's called ahead of the curve. Okay, so that's extremely good to know. In fact, yesterday I was talking one school. I'm not even talking about a financial institution. They phoned me and said that how can we? It's 350 people school, student school. How can we enhance our privacy as well as cybersecurity because we are conducting online classes and we don't want any incident to happen. So to that extent, we felt glad that yes, people are taking note of this. Okay. So where financial transaction required, it is absolutely a must. Otherwise, people will lose faith in digital India. If supposing they're getting hacked and they're losing money, the poor people will be affected. It is absolutely not a done thing. Okay. So yes, a lot of awareness and upliftment required. So there are two parts. One is we need to build a very strong, secure, and privacy enhanced cyberspace. The second thing also, and this is for our Indian industry, is that it's a $250 to $300 billion market worldwide, and certainly that market is waiting to be explored by our all our technology companies and all. So this is actually an opportunity. The worldwide unemployment rate in cybersecurity may be in the negatives, probably -4% or something. And when privacy laws come in, there will be a million privacy professionals required. These are all the opportunity side of things, right? So either case, there is this need to really ramp up our expertise and awareness, right? So I hope that addresses in some measure.
Thank you. I think that's really helpful. Coming back to Mishi, to you, you have seen how financial crimes are investigated in US jurisdiction, and you have fair bit of idea how it works in India. Do you believe that having the adequate safeguards, what we mentioned about in protection bills and all, they've actually worked there where the privacy of an individual is respected while investigating financial crimes? What's your practical experience basis your understanding there?
So I will say one thing is that the question is a little, you're touching upon a lot of these strings again. I think that institutions, we are only concentrating on financial crime. I think financial institutions are robust enough and sophisticated enough to understand what their data obligations are. And when we talked about the privacy enhanced technologies, we were talking also about the fact that there is already a lot of concern about the fact that what gets shared with the agencies is a well-developed system. Now, we can all argue about the fact whether it is, which is the Fourth Amendment here, how that is, how secrecy around all of these things work, whether a lot of privacy advocates would think that that kind of a system should also not work. In the same breath, because here at least the financial institutions have been more and more recognizing cryptocurrencies, we've also seen an uptick in organizations which offer services, a slew of organizations which are offering now services for which is called blockchain surveillance. If you see whether it is recently what happened or there was a hack by this 17-year-old developer on Twitter, which the money was again traced to the person. Now, these kind of organizations who can now monitor addresses, transactions, and make sure that the anti-money laundering ones or they are also CFT compliant, that industry is fast and growing. At least there are 20 such organizations which are already in place, working with intelligence agencies, etc. Whether you talk about Chainalysis, Elliptic, or CipherTrace, etc. So I will say, and all of them are well aware of the fact that when they are dipping their toes into this kind of work, there is going to be compromise of certain kinds. Now, how far can they go and how much of a privacy surveillance problem it is? It will again vary from jurisdiction to jurisdiction. Some people are of the view that some of this is going to lead to some kind of human rights abuse. We've seen that there were Western tech firms which were cashing in by helping authoritarian governments to surveil dissenters. Now that becomes a major issue when the privacy advocates talk about. But if we are just talking about investigatory stuff, that's very different. I think earlier before we started the panel, Nakul had been talking about Section 91 Criminal Procedure Code in India. My practice in India, which other people manage mostly, but we've at least seen that is like national security. It's like a catch-all phrase. Whoever feels like doing whatever they want to send a 91 CRPC and say, do that. I have had clients in India who have received 91 notices for content takedowns. And I'm like, these people know it better than the ex-union minister for IT. And we don't need defamation lawsuits. We don't need anything else. Just file a 91 and get everything. The assumption is you can get data, you can get things removed, you can do everything through that one section notice. So overall, what happens is that we've all seen majorly, we can have as many bodies, as many enforcement actions, whether it actually translates into action and how it is operationalized is a very different story. Our data protection authority is still not there. The act is there, and there's been a lot of discussion about, is it going to actually be run by people who will not be independent of the executive arm of the government? Because even in this bill, there is a complete exception to whatever the government wants to give access to its agencies. I have a major problem in thinking of data as this asset. You can fill in data as the new gold, oil, whatever is in vogue today, because every day it changes. I think as long as we keep seeing that, oh, we have to monetize this, then we are not thinking from the perspective of the user. Because the user is fine to get some kind of useful targeted information, even in form of advertising, but the user is not fine about data being collected, profiles being built, and then they land into some kind of discriminatory, at the end of some discriminatory practices. And I think that's a major way how we define, how it should be driving. For businesses also, Dr. Sriram was saying that the large businesses may be prepared. The small businesses, even for the large businesses, at least the ones I deal with, I see much better preparedness because a lot of business also deals with European data or California data. So they're already preparing, they've already done a lot of work. And now we are GDPR 2 years into, already up there. So they're much more sophisticated with that. CCPA also, a year and a half has gone by. January enforcement started. So those companies, even if they're based out of India, but if they're catering to citizens who are based in other jurisdictions, much more sophisticated than how they deal with Indian citizens. And the problem also is there is no clarity. What is my clarity right now? I don't know what is expected out of everything. IT rules are subordinate legislation. They're also jumping into privacy right now. So I think that there is very little clarity for businesses. Business is fine doing a lot of stuff as long as they have clarity. And so are the citizens. Clear laws, large fines, quick enforcement, and independence. That's what we would require. And I have seen that a lot of that is moving here. DOJ has a very sophisticated now, at least a group, which has been studying the compliance and how to deal with all of this with cryptocurrencies. They've also figured out that GDPR, using Article 6 as well as Article 49, they can get the information they would like. So we're moving into a much more robust framework. But even here, we are far further along than India, but not as far as we would like it to be.
Thank you. That's really insightful. We are mindful of time. If we'll be open for questions for everyone. We already have a couple of questions here. Let me tackle them. The first one is, while privacy enhanced technologies are the next big disruption in the financial crime compliance space, what are some of the regulatory aspects which we should focus upon prior to the adoption? Nakul, Asim, you would like to take?
So I think, let's say the PDP bill has this concept of privacy by design, and the privacy by design, as defined in the PDP bill, is a very broad concept which deals not only with how the information flow, what should be the organizational setup, but also the technology. So I probably feel that these technologies will probably fit into the concept of privacy by design, and so that's probably a sort of a response as far as the regulatory framework is concerned.
Thank you. We have another question which talks about a technical question. It says, is it fair for companies to not enforce privacy policies till the personal data protection bill is passed? Where does that leave the user to data privacy?
If you can repeat the question.
Is it fair for companies to not enforce privacy policies till the personal data protection bill is passed? I mean, as of today, we are talking about the bill will come after 2 years, 3 years, 5 years. We don't know. Till the time, should companies on their own start adopting, privacy policies? Look at global standards, what Mishi mentioned about, and ensure preparing to that. Should companies start adopting that? That's the question.
Yes.
Yeah. So I think, let's say the current existing data protection, and it's very sketchy. There are only 2 provisions relating to data protection and IT Act. Most of it is in the subordinate legislation. That is sort of a minimum requirement. Now, if the company consciously takes a decision that it should comply with what are the principles which are in the PDP bill, well, that's great. That's very good. It has a cost implication, but I think it's for the company to do it. If they are doing it, that would be great.
Nakul, Mishi, you want to add on?
It's about the first question you asked. As I said earlier also, Europe, which does have experience with GDPR, but even the European banking industry is calling for much more legal guidance on how banks should interpret data protection rules in their anti-money laundering network. I think the regulators still have not figured out and providing complete kind of guidance which will establish that this is what is required. The privacy enhancing technologies obviously are taking into account the fact that the PII is not shared or compromised as they implement it in data sharing. The second question which is asked is that from my point of view as a user, I want to use services who are much more cognizant of how they're taking care of my data, not only for my privacy, but also for security purposes. I don't think that I want to shop anywhere or I want to use any service which does not take into account what having my data, processing my data means. So, more and more users are getting conscious of the fact, whether it is financial data or health data or any other kind of information, it is much more useful. If companies are realizing that it is easy to monetize it, I think users are also recognizing that right now it's all in their hands because nobody's coming to protect them. So when I will advise a business, there is, as Asim said, obviously there's going to be a cost about it, but and Dr. Sriram earlier said that it's a cost of doing business. There are a lot of things we implement because the business needs to either sell a unique selling proposition. You can make it into that we are the people who take care of your privacy. We are not compromising. And if we are going to operate in a market which is going to be competitive, more and more players are going to be offering that as a feature. And the lack of it is going to be considered as a bug. And so I don't think that companies can just say, oh, we'll just sit. Obviously, obligations will change. We don't know whether this is the form of the bill which will come. And that's why the advice which Asim said about the fact that principles are important and one can try to at least draft based on principles.
Thank you. Thank you. Sorry, I think we are conscious of time. I believe we are 6:40. So, well, I think what we understand and what we hear from experienced panelists, experts is that obviously there is an enhanced focus on the privacy angle of individuals. There is a definitive and urgent need to have a personal data protection bill, and there has to be a detailed and a very robust framework which not only talks about law but in detail lists out the steps that are required, the procedures that are required, the policies that are required to be implemented to protect privacy. And at the same time, we do hear from our experts that financial crime is on rise. There has to be a balance where we are able to kind of take financial crime investigation to a logical conclusion and prosecute and reach to a right judgment. And at the same time, we ensure confidentiality of individuals till the time they are proven guilty. So I believe we are all at same page, and we hope that the bill, which is indefinitely delayed, sees the light of the day. With this, I thank all the participants for their time and all the panelists for their expert views on it. Thank you very much and have a good evening, everyone. What do you?
Thank you, dear panelists, for sharing such valuable insights and for taking time out to join us today. We would like to thank our session partner, Refinitiv, Gold partner, Reactor, Bronze partner, Onfido, and Knowledge partner, EY. Ladies and gentlemen, with that, we conclude the first day of Pursuit 2021. We look forward to seeing you online tomorrow at 10 a.m. for the final day of the conference, complete with Power Pack sessions. Thank you very much.